We're glad you're still with us here on Morning at 10 TV. The Kickstarter discussion is getting underway, and we shall be talking the building of a constitution and the entrenchment of rule of law for any one country, paramount elements of the constitution and the structure that does support implementation and execution of the provisions therein, as well as how transitions are made, and this is all from a legal perspective. Now, if you hear a lot of legalese this morning, please bear with me. I'll endeavor to ensure that we are all on board, especially from a layman's point of view. But our core of the discussion is the fact that constitutions are foundational to democracy, the rule of law, human rights, and good governance. But poorly designed constitutions can increase discord and conflict. Today, we are going to attempt to dissect the kind of transitions that constitutions undergo with a critical look at Uganda's case. I'm joined on site by Sarah Birete, the Executive Director at the Center for Constitutional Governance, and joined too by Advocate Eddie Nanglu from Nanglu and Mugoda Advocates. Ladies and gentlemen, many thanks for joining us.
Thank you for inviting us, and good morning. Yes.
Later, we expect to be joined by Honorable Fred Mukasambide, the Vice President of the Democratic Party. We also expect another guest, but let's get underway with the discussion as far as we are concerned right about now. Before we go into the nitty-gritty of the theories and the perspectives as defined in our preamble, there is something of a constitutional battle in the Daily Monitor today, something that has been brought to our attention by an advocate, a journalist, and one who describes himself as a fighter for the common man. Gawaya Tegule is challenging the establishment, especially with regard to the first family, the fact that we have the First Lady, Minister for Education. We also have the first son, Commander of the Defense Forces, but also a brother to the President who operates in what is described as a quasi-government position, dishing and apparently ensuring that people get some money once in a while. I will ask the question first. Has any one of you read this article?
I have read the article, but I haven't yet read the petition. But matters being raised seem to be fundamental, and I hope both parties can be heard by the court, the Constitutional Court, and the petition be dispensed with, especially since we are going into electioneering season. I wish it could be heard and determined before the elections.
Do you think this is the start gun to that electioneering process ahead of 2026?
We have been in a permanent electioneering phase, and the campaigns have started with disguised Thanksgiving functions by ministers, and if you want to confirm that these Thanksgiving functions are early campaigns, when the new lawyer attempted one, you saw the chaos that the police caused with the, that canister that was thrown at Bobi Wine, the attack, even when there was no commission on the road and there was no need for the chaos that police caused. But they know that if opposition also starts Thanksgiving, then they are also joining the platform of early campaigns, and that's why they attacked NUP leaders.
Okay. Eddie,
yes.
The article that's carried by the Daily Monitor today, it's very prominent on the first page. It's a contravention of the Constitution, various provisions, according to the petitioner, Gawaya Tegule. Have you read the article?
Yes, I have. I read the article this morning, and also I've been following your discussion earlier on.
Yeah.
I think we need to bring these matters to light. We have been biting our tongues for so long not calling out wrongs in the public. We need to understand whether people enjoy these offices here on merit or it is because of their stature or status in society. I think as a matter of fact, I am for this petition. I would want to see how the court shall construe and maybe resolve this matter here.
All right, we shall all be waiting for that to play out. We hope exactly the way you say, the things can be done expeditiously. But the Daily Monitor is as good as it always is. David versus Goliath. I'm hoping David doesn't miss again. When
David,
it comes to throwing this.
David never missed before. David didn't
or rather
miss
doesn't miss in this particular incident.
David didn't miss, and we need this issue to be put to rest as well.
The reason I said so is over the last 2 weeks I've seen a meme that was questioning what if David had missed to Goliath. So when the Daily Monitor says David versus Goliath, we do hope David stays true to form. Let's now step into our discussion for the day. The constitutionalism, the constitution, preservations of the law. What is your take, Sarah Birete, on what is the classical view, the revolutionary political change, apparently that may result in constitutional change as an extra legal modification of the fundamental principles of order and legality or illegality?
The question touches on the basic structure doctrine and constitutionalism. This basic structure of the Constitution highlights core elements that confirm the principles on which the Constitution as a grand norm and other laws are governed. Key elements of the basic structure include, for example, the fundamental rights and freedoms, components to do with the transition of power, doctrine of separation of powers, and transparency and accountability. In the case where litigants were challenging the removal of age limit, the Supreme Court confirmed that the doctrine of the basic structure applies to the Ugandan Constitution and so many other constitutions, Bangladesh, India, and others. Although they fell short of admitting that tampering with the structure, the components that were put in the Constitution to provide for orderly and peaceful transfer of power was an act of tampering or attempting to remove the basic structure in our Constitution. The Odoch Commission, which compiled citizens' views on how they wish to be governed, had two key terms of reference. One was to make sure that the views of citizens on how they wish to be governed are gathered, which they did up to sub-county level in this country. But the second key term of reference was to put in place the structure for orderly and peaceful transfer of power. So the basis of the Constituent Assembly constitutional making process was on the basis of the strength of the recommendations from the Odoch Commission. The Constituent Assembly somehow, I think it was an oversight, they failed to entrench provisions that are part of the basic structure of the 1995 Constitution, like term limits. And that's how we have seen, this alteration to the extent where we are, taking us back to the Gawaya Tegure petition, turning Uganda into a kind of monarchy without supporting a legal framework because of a permanent president or one person who has permanently occupied the seat of the presidency for now coming to 40 years and still counting. So once you alter those core elements, you cannot say that you still have the same constitution. Although we still say the 1995 constitution as amended, but maybe now we should have been on the 8th constitution instead of the 4th constitution, because it has changed a lot in character.
All right, Eddie, the changes in the Constitution and what Sarah describes as changes in character, isn't that what the Constitution is all about? The ability for it to be changed in order to attend to the dilemmas of the day, but also push forward the needed adjustments for governance purposes.
Now, the law is alive. The law must evolve. The law can never remain static. What you must understand is that what we are doing today is we're having convenient amendments to entrench or to cater for individual interests. If you will connect to where we have done any kind of modifications, you will realize that it has been to cater for a specific interest. We have left what is the basic entrenchment in our Constitution, and now we are trying to entrench an individual to last as long as he can. What is now being mooted by the Parliament is to introduce a system where it is the MPs that vote for the President. Now that is wrong. That offends Article 1 and 2 of the Constitution. If you deny us the right to vote for our President, then how do we now, how do we say we are living in a democracy? Or how is even there a noble framework of governance? You can't do that. You can't begin to set that up. Now, because we cannot trust the nature of the amendments, the nature that is being portrayed as how they are deriving or how they are even introducing these amendments is wrong. I think it shouldn't be the case. It should even stop, as a matter of fact.
You seem to suggest that electoral colleges in the conduct of elections are fundamentally flawed frameworks. Is that so?
I agree it is flawed. It shouldn't be even acceptable in our systems today. The public and the country need to go to the polls to choose their president. Now we are introducing amendments simply because we want to favor a given sector of society. That can't be the case. The notion behind amendments is to enable the public interests be achieved, which we can't achieve through such a proposal or through such amendments.
Okay. Sarah Birete, I want the honest answer. Did the framers of our Constitution in the run-up to 1995 fail to look ahead and see what could, for example, be occasioned upon the people in terms of the political space, or have they simply been failed? Because the reason I ask this question is when, for example, you juxtapose constitutions across the world, there seems to be a way Americans, the British, and others saw 200 years ahead. So much so that most of the provisions of their constitutions do attend to the dilemmas that seem to crop up, either on an yearly basis, something that we do not seem to have for the sake of Uganda. We tend to legislate ourselves as and when we face the dilemma, and then we have to change a constitution in order to deal with a particular problem. The men and women who sat down in the Constituent Assembly and designed the Constitution as we have it today must have failed at a certain point to see ahead. That is, if they've not been failed.
You know, the spirit of our Constitution is captured in the preamble. The preamble is a very short, very short
and deep.
Yes, and deep component of our Constitution. And in paragraph 3 of that preamble, the framers of the Constitution did affirm that this was a durable and permanent Constitution. That does not mean that the Constitution should not have been amended. And if you compare with other constitutions of other countries, each country has its unique political context that it should legislate for. We were coming from the history, which is also captured in paragraph 1 of the preamble, the turbulent history, you know, characterized by armed conflict and unstable constitutions, the first, second, and third constitutions of Uganda. The making of these constitutions did not have a big input from the people. The Lancaster Conference that ushered us with the independence constitution was just a few handfuls of people that attended that conference. Then you come to the second and third constitution, the abrogation after the Uganda crisis. Then we had the coup, which now changed the legal order of Uganda, the Idi Amin coup, where constitutions were suspended. And then after Idi Amin reinstating the 1987 constitution. But we also had an element of transition, where the president was the speaker of parliament under the NRC. And then Chigongo had to step in as a deputy speaker. And this is the transition that ushered us into the 1995 constitution. So did the SIA delegates fail to look far 200 years ahead? When you talk to some of the people that were in the Odoch Commission and later Constituent Assembly process, they said that they were hoodwinked by what they assumed was the goodwill of the leadership then. The Constituent Assembly had planned to entrench term limits under our Article 260 that lays out a procedure of amendment of the Constitution. And they are entrenched articles that you can only amend by going through a referendum back to the people. That's why they had wanted to put term limits. But according to the confessions, when they met the president said that who could be mad to tamper with things like term limits, that there's no need to entrench. And they relied on that, which they assumed was goodwill of the people. But where are we now? So to me, the lesson that we pick from that is that laws should not be enacted based on the goodwill of a particular leader. Because as we see, first of all, it is not a guarantee. Two, people change according to interests, but also it was very wrong to assume that the constitution should have been made according to the wishes of one citizen who happens to be a president. That was fundamentally wrong. And the amendments that have followed, the key political amendments, have also been made, or the constitution has been altered to favor one individual. Very fundamentally wrong. And that jeopardizes our constitutional journey as a country.
Is there an opportunity, Eddie, for any fundamental changes to be made to the point where the goodwill of the framers of the Constitution can be achieved, away from another set of goodwill turned apparent badwill on the part of the leader of the day?
What is happening is we have known our mistakes. People have realized that indeed some of the amendments were in bad faith, and they have cost us very heavily. You realize that the debate in the corridors is now, how do we restore term limits? This has been said by Mao. He said among his terms of his agreement with the NRM was that we should restore term limits. How
far he is on that?
Yes. Of course, recently he's struggling to even implement. But as a matter of fact, as my sister had said, we got caught up in trying to appease the individual. And now in that we lost our spirit as a country. But it's not lost completely. We can still indeed redeem the situation. The debate to restore some of those entrenched provisions is one we must be having. Is one to adopt, is one to consider, which I think we should in the days coming.
Could you walk us through what informs that hope? How is that going to be achieved?
No, there is so much to hope about in this country. As a matter of fact, so much wrong is going on. But you know, in the moments of the wrong is where you also begin to observe the right things. His Excellency has spoken out strongly against the grant of bail for thieves. Now, for us, we feel that is extremely wrong because of some of those statements there, he has placed the judiciary and the courts under a difficult situation. Many of them are torn between his agenda and what the law determines or what the law directs. Now, recently, and in many even other countries, there is judicial activism. Through judiciary and through the courts of law, a number of principles are being adopted to restore sanity, and also restore dignity in the process. You realize that the Supreme Court in one of the petitions of the presidency aligned and gave directives on what should be done before the next elections. Those haven't been done as yet. But of course, we shall keep on demanding that those should be done, those must be done. In such a manner is how we are going to be able to achieve a thing or two in trying to realign our country to where it's supposed to be going.
Okay, that effectively talks about a transition at a constitutional level in terms of amendments and the constant and multiple reforms that ought to be adopted in there.
Now we are doing it through the courts of law because we are not able to do it through the parliament. You'll discover that the parliament is not able to achieve the needs, the desires we have. So we need to push these proposals through judicial activism so that the courts of law can be able to speak up for what is wrong and what is right. This is possible, it's achievable, it's a matter of time, but it's possible.
Are you part of that movement, Sarah Birete?
We have, I think, about 5 public interest litigation cases pending before courts of law as Center for Constitutional Governance, but we also support other litigants that come forward to enforce and protect the Constitution. Article 1, 2, and 3 vest the powers to protect and defend the Constitution against all forms of authority or leadership in the hands of the citizens. But we have a challenge of limited knowledge of constitutionalism amongst the people.
Great.
And the people have failed to protect the Constitution because of these knowledge gaps or challenges. People view the Constitution as a kind of lawyer's document, not knowing that the Constitution should be a handbook for every citizen.
A Bible.
Like the way we read the Bible. The Bible is not a preserve of the people that take up to the pulpit to preach on Sundays. It's everybody's home. Students carry Bibles. That's the same way we should move with our Constitution and call out to leaders whenever there are attempts to abuse or abrogate the Constitution. But this knowledge gap creates a very big vacuum to the extent that even some of the members of our legal fraternity, you find that they only look at the Constitution when they are researching 1 or 2 cases, and they don't follow up through the governance procedures of the country. And this is very absurd.
Okay. That's very, very interesting, and I'm hoping that the fact that the Constitution can begin to be held and read the way the faithfuls read the Bible can be achieved. That's down to ensuring that, for example, in schools, a Constitution is provided for every student. Does that even work?
Right now, our read volumes and the laws of Uganda are no longer free. Among our complaints as the ULS is that how do we begin to customize some of our legislations? Right now, you cannot look out for these laws. You have to pay. It's about 2.5 million shillings. Now, you can't expect an ordinary person to have these volumes available. You can't expect them to read. Yet we are under a system where ignorance is not a defense to what you could or could not have done.
Are there compressed versions that can be...
No, they are not even online. They have been taken down and you cannot access them until you pay that volume of money, which is extremely wrong.
All right, Sarah and Eddie, allow me welcome on board Honorable Malende Shamim, the Woman MP for Kampala and also advocate. You're welcome to the program.
Thank you so much.
I'll throw you right into the frying pan. There are concerns, for example, especially in the entrenchment of constitutionalism in the country, that the current crop of members of parliament are disinterested in ensuring that the constitution is adhered to, especially by the political actors, and there isn't any form of enthusiasm that demonstrates a need for working towards reforms, especially in line with the goodwill and the intentions of the framers of the Constitution as we have it today.
Okay. Thank you so much. I want to also say good morning to all our viewers and my people of Kampala and Uganda at large. But allow me to send my condolences to the family of the late Jolly Mugisha and to the entire NUP fraternity and the all change-seeking lovers, and maybe to the women folk, because she has been a very strong pillar when it comes to spearheading matters to do with activism, women and gender, gender rights and women issues. So we shall forever miss her, and may her soul rest in eternal peace. Going to the question that you have raised, I think it's no longer in doubt that Parliament of Uganda, where I belong, is not clearly independent on its own when it's executing its mandate. And this is not something now we can hide away from, because we know the Constitution guarantees that, Parliament is an organ of government and is supposed to execute its mandate independently. It's supposed to listen to the voice of the people, air out the voice of the people, and come up with laws that, that are going to govern and help in social justice and all that. But we have seen situations in our Parliament of Uganda where the will of the people is not upheld because there is a lot of interference from very many corners, mostly from the executive. And that is an issue that we have raised on several platforms, and we were actually suggesting that that if possible we should begin from where the Speaker of the Parliament of Uganda is elected, and how different office bearers are elected or appointed in that Parliament. And we think that that could help, because right now we are faced with a situation whereby we have the leadership of Parliament, especially the very top, that looks at the president or the sitting general as their parent, and they say, this is my father, I look at him as a father and all that. So we are looking at a situation whereby it is very hard for even a sitting speaker to actually do something that they think may contravene the will of a person they look at as actually their father. So we have a problem that when the speaker is sitting in that house, or the deputy speaker, or whoever is presiding over the house, that person must not be getting any directions from any other, areas or from any other persons apart from the people. The voices of the members of Parliament should also be the voices of the people. But we've also seen situations whereby some legislators have also been, have participated in being compromised and not executed their mandate. These are facts that we must speak. They may be bitter facts, but we have to speak them. When you are in that Parliament, you have to remember the oath, that you took. And it has to be the one to guide you, and the voice of the people that actually sent you there, that is what is supposed to guide you. But we have seen situations whereby when some legislators reach there, there is some bit of compromise, and that is an issue that we should also deal with. Maybe we should throw it back to the voters. How do they vote? How do they pick us, the legislators, before they send us there? But also there is also an element of the numbers. We have situations whereby, we have a mandate to protect the Constitution, to preserve it, to fight. It is actually an obligation for each and every person. But we have seen situations in Parliament of Uganda whereby even if you would want to protect a particular provision, you want to fight and protect the Constitution, we saw it on the age limit, on the term limits, and some other similar situations. But, you know, there is a problem of the numbers, the other side saying, you know, we are the majority, whether you like it or not, the thing is going to pass. So we have that problem. Maybe we should start discussing on how we are going to deal with such an issue. Maybe it should start with saying maybe the speaker, if the ruling government, for example, we can say that if we have maybe a ruling government, we should have the person presiding over Parliament to be from maybe the opposition. Maybe we should start looking at so many other suggestions. I know a lot of research has been done by the different organizations and all that, and they are very, very important. Maybe we should look at such reports very critically and ensure that maybe we ensure that those reports are implemented, especially the recommendations that are put therein. When it comes to constitutional and electoral reforms, of course, out of experience I have seen, even when I'm practicing the law, when I'm representing the political prisoners, there is what they call selective application of the law. There is order coming from above, securing a police bond. The officer will tell you clearly that let me first receive a call, I have to first go for a meeting, you know, such issues. So there must be the will to respect the law and to uphold the Constitution by each and every one of us. So yes. Okay,
just finalize that submission.
Yes. So where in a situation, in a country whereby the law works when they want it to work, you'll get problems like this and so many others. So that is exactly what is happening in Uganda. Even if you go for a case, I do political cases, if they do not want someone to be released, even if you argue all the law, the person will not be released. It will just be one phone call. And when that phone call says release the person will be released. So, of course, for us, we keep on fighting as lawyers. We keep on getting all the laws that, you know, we studied in school. We keep on saying the law must, you know, we must follow the law to the letter. But we have that challenge, and it is a fact, and they also know it. I have done it. You even go to a police station when you're going for political prisoners, and they tell you, ask them what offense. They tell you, Shamim, you know the offenses, you just choose one. They have their cases, I now know them.
Already
inciting violence, unlawful assembly, disobedience of statutory what? They are those offenses that they have classified, common nuisance offenses that are now becoming political. You're given an option offenses.
To choose which offense.
You know, when you go, for example, when I go to a police station for a political prisoner, I may say, I want to know why my people have been arrested. Yeah? What are you charging them with? And they'll even laugh at you. They'll laugh at you and they say, Shamim, you know these things. You know those cases. You choose one. If you want to go and tell the media, tell them anyone you want, because we are going to get one of those ones and put it on these people. So it is that funny. But it has also gone to another level now, the level to which it has gone, that now they can get a file, for example, of habitual criminals, maybe when they are in prison, and then when they get this person whom they think is stubborn politically, they can, you know, join you on that other file also. That is now another new trick of handling political prisoners and presenting them in court martial. So those are all things that show that, you know, there is no will to respect and uphold the Constitution, and yet it is a duty of every individual, the state, organization, parliament, whoever, every person, even if you're security personnel. So we need that collective, you know, that collective will. We need to, all of us, participate and say, this is for us. The Constitution is for us all. It is not just for just a few individuals. The law is for us all.
Okay.
Yes.
Sarah Birete, you must be itching to submit on some of the concerns raised by the Honourable Member of Parliament, but also help us on the separation of powers. A constitutional theory has it accepted that we know the judiciary works independently away from the legislature as well as the executive, but her submission seems to reveal what is an open secret, that the things are not working as they ought to, and there's a lot of interference here and there. But she has said some aspects. You must be having either question or two that you can throw to her to clarify She has just completely disowned the ability as a legislator to condition the kind of change that she is mandated to condition as a representative of the people.
Well, the key function of Parliament as enshrined under Article 79 is to protect the Constitution and promote constitutional governance in Uganda. But the caliber, I want to agree with the Honorable Shamim that the caliber of our Parliament, and I want to state that since post-independence Uganda, we have the weakest Parliament ever. And I hope that the voters can rectify this. So we have 1 year to go for elections. We have the weakest Parliament that you cannot rely on to carry out its function under Article 79 of the Constitution. The leadership has displayed what it can do, because most of the agenda of Parliament, there is so much power in the leadership, and unfortunately they are operating from their weakest points. So when it comes to other institutions of government, like under Article 99 of the Constitution, it's very clear the executive power is derived from the people, and the function is to protect the Constitution. I want to bring in the Tegure statement where he's talking of state capture by first family. You see the statements of the CDF, the current commander-in-chief of the forces. Article 208 of the Constitution is very clear on the character of UPDF. Must be national, non-political, and non-partisan. But you have the CDF on rampage. No matter on Fridays, Saturday, and Sunday, writing up Twitter with controversial statements that he shouldn't be making by virtue of his office. But who is his boss? His boss is the father. Has he ever called him out on abuse of the Constitution, of conducting himself outside the expected code of conduct of the army? No. So both the son and the father have failed in their duty to protect the Constitution and constitutional governance in Uganda. You come, so you have a failure at the legislature level because of the weaknesses. You have a failure at the executive level because we are governed as a monarch when the Constitution says otherwise. Now you go to the judiciary. The judiciary exposed itself when Honorable Chaguranyi attempted to file a petition after the 2021 elections. The manner that the judiciary conducted itself was appalling. The conduct stopped Justice Sache from reading her dissent judgment was unfortunate, and that marked the failure of judiciary to protect constitutional governance in Uganda. So you have people basically left on their own. We can now go to the proposals by the Minister of Justice, because he's the right minister to protect constitutionalism. He opined an article in New Vision that PRU will win the next election. PRU is registered as an NGO, company limited by guarantee. How do you even make such a case? So that is our dilemma as Ugandans.
Eddie,
yes,
there's a lot to chew on that, but also help us understand the dilemma of activist judiciary.
Now let me say this. The law is simple. That the way you choose to apply it is the way it will be applied to you as well. You will note that when Kizza Besigye was at the High Court rearrested by the Black Mamba, at that time there, not much was even done about it. The parliamentarians sat by knowing we are not touched by this situation here.
This kind of scenarios, yeah.
When they picked Honorable Akamba, in a similar manner, we called them and we told them that it's now happening to you as well. Most times you will do nothing because you are not the victim. When they say there is no granting of bail And over time, us who apply for bail struggle to obtain bail. Right now, it is the MPs who are being detained. A leader of society who has known a known address, who has known, you know, we can easily find you, but you're kept in custody for over 60 days because the word has been issued. And this is the plight of every other day people who are charged. Now that is so wrong under any kind of governance. Some of these rights must be a guarantee under the law. Now you'll find that they haven't been accorded because the persons who must implement or who must legislate haven't been victimized. But now they are also victims as well. My hope is that it is going to work out in one way or the other. Since they are now trying to avoid being victims, they are going to now maybe enact different kind of legislation to guarantee some of these freedoms here.
All right, let me again put the Honourable MP on the spot. We are receiving reports that the process of mooting, where members of Parliament will be required to vote the President instead of the universal suffrage, is well underway, and there is a collusion on the part of some members of the opposition to vote in favor of that kind of arrangement. We haven't heard your name specifically, but when they say members of the opposition, one is inclined to think you might be among them, who think that at any one point in time, MPs, if it comes to that, and you have to elect the President, is that something you're going to abstain from, or we are going to see another development as and when that happens?
Of course, we are totally against that proposal of, you know, it's like taking
as MPs, the Parliament Collective, your party, your association.
I'll first
as
speak
women?
for myself. On behalf of the people of Kampala that I represent, and on my own behalf, we do not support that proposal to have the President elected by Parliament. And also on my own behalf, from the legal perspective, being the lawyer that I am, that takes away the powers of the people to elect their preferred leader, to elect their president. And that is something that I cannot stand with personally. At a level of a lawyer, but also as a leader representing the people of Kampala, and as a parliamentarian at a national level that I'm expected to legislate. The laws that pass there affect everyone at, you know, at a national level. So even at that level, I do not support, and I will never vote in favor of that law. That is my decision from the beginning, because even the few interactions I've had with my people, everyone is totally against it. But even starting with me, even if I was not a leader, I would not stand with that. Then, on behalf of my party, I know it is their position, because we've held several meetings as the leadership of the National Unity Platform, on which I sit as the Deputy Legal Secretary. But I know that in due course, the spokesperson of the party and the President, who is our official spokesperson according to our Constitution, will come out and also have a say on that and make it clear to the public. Of course, on behalf of Parliament, I cannot speak on its behalf because it has a spokesperson and people that will communicate on its behalf. And but precisely, the issue is taking the powers of the people and giving them to parliamentarians to vote for them a president is going to be very catastrophic, given the nature of Parliament that we have. Not even this Parliament, we've seen stupid, okay, for lack of a better word, we've seen some stupid laws go through Parliament. and even the ordinary citizen asks you, how did this law, where did it pass? This is a very bogus law. This is a law that has been passed. They have not actually consulted us. It is a law that, you know, that is actually affecting us. So if you couple it with what the Honorable Mama Sarah Birete has submitted, the weakness of our parliamentarians, or our legislators
at this particular
this particular parliament, where I belong, to which I agree that most of them, or most of us, are weak. You cannot entrust those people to do anything with passing such a law, because you cannot entrust them with protecting the will of the people. Yeah?
Okay.
Because we have seen situations where some are easily bribed. Okay, it's not only this parliament, we've seen it even in previous parliaments, and maybe it is likely to come. But maybe it's
likely to come.
Maybe what I'm saying, even in the coming parliaments, if the executive does not change its tactics, if it thinks that we just have to bribe the leaders and, you know, put some of them on our side, with such a parliament whereby some parliamentarians can easily be hoodwinked, where some parliamentarians can say, let me pocket this money and do that, then you're going to have some bogus laws pass. Okay. So it is now upon you, the legislator, to execute your mandate, stand on what your people have told you, and stand your ground to protect the will of the people. So it is not, you know, it is not something to dispute that there are some opposition members, maybe who may be, you know, may be in bed with the sitting NRM. That is a matter that has been here. We have seen it. Yes, we have seen it. So that one, it may come, but it will be very unfortunate. So it is upon each legislator to stand their ground. But we are also calling upon Ugandans to speak. Because ideally, if I speak, I'm taken to be the voice of the people of Kampala. But we have some legislators who will come and speak because they have eaten something, not because that is what their constituents have said to them. Okay. So in such situations, we need the public to join in and say no to this, to this kind of proposal, even before it goes anywhere. When
you say legislators have eaten something, I should remind the public that the language board in England, the English language board in England, has finally accepted the word kitu kidogo to be included in the English dictionary. So you can rightly go ahead and preach. When you are making these submissions, you can say, for example, kitu kidogo. That is perfect English right now. No doubt. It's also, it has also allowed the Rolex, Uganda Rolex, to be included. So
even Boda
Boda was included a long time ago. So now it's perfect English to say, I think I will do with a Rolex. Now, if you are in Switzerland, please mind how you use the word Rolex, because people might totally misunderstand you.
True.
As we enter the final bend of this particular discussion, what are those pain points within our constitution that are different or detached from the dilemmas of presidential term limits, age limit, that continue to stifle any attempts at reform? She has spoken very ably about the fact that there are some laws that, well, they see the light of day, and people are wondering, how did this come into force? Does that mean we have sets of laws that are currently in force that are totally out of order and maybe were passed behind the normal processes within Parliament? Could you name any that are fundamental to our move forward?
Well, there are a number of laws that are even being challenged in courts of law for being unconstitutional, including the Computer Misuse Amendment Act 2022, the Public Order Management Act, still being challenged at Supreme Court level, where there is no memorandum of appeal on record, more than 5 years of filing a notice of appeal. And if our judiciary was conducting its affairs in accordance with the judicial guidelines, they would have struck off that notice of appeal that does not have a memorandum of appeal after 60 days. But they never do. And the same notice is being used by police to continue implementing expunged sections of the law that violate the Constitution. That's a classic example of unconstitutional laws and how the arms of government are conspiring to keep them on our record as laws, especially the judiciary. When it comes to the political context, and I want to just submit on the UPDF Act and the conduct of UPDF in Parliament and in elections. The UPDF Act referred to representation of officers in Parliament as listening posts under the movement system. And the justification then was that the army or men in uniform, either as rebels or government armies, have been the biggest disruptor of our democracy. Either as rebels in the bush or as government officers abusing fundamental rights and freedoms. So they thought they needed to listen in, and that's why the Act refers them as listening posts. And this provision has not been amended. Then you have a change from the movement system, where everybody belonged to the same system, to a multi-party system, and you keep these so-called listening posts in a partisan arena that contradicts Article 208 of the Constitution on the character of the national army. Non-political, non-partisan. That character is lost in a multi-party dispensation with the presence of the army in Parliament. To make matters worse, even when there are seats on the opposition side, the army sits with the ruling party. They squeeze themselves in that confusion, meaning that the UPDF conducts itself like a military wing of NRM and not a national party, as a national army as defined in our Constitution. We need to rectify that dilemma.
All right, thank you very much, Cesar Birete. Time now for a short break. When I return, I'll be engaging you, Eddie Naglu. Of course, we have had enough, not enough, but some quite exhaustive time with the ladies. When we return, we shall continue with this conversation, but begin to look at the way forward, especially when it comes to attempts and the need to rectify the fundamental wrongs within the Constitution, as of course Uganda does experience it. I'm Chris Higenyi, so stay with us. We'll be right back. Morning at 10 TV is still here. Stay with us. Welcome back. It's 20 minutes to the hour of 9 o'clock. You are watching the Kickstarter segment of Morning at NTV, and we are discussing the building of a constitution and the entrenchment of the rule of law. What are the paramount elements of that kind of structure, and why does the constitution look the way it does, especially for the fate of a country like Uganda? Allow me go to Eddie Nanglu, the advocate with the Nanglu and Mogoda Advocates, to help me understand what is fundamentally a disconnect in the dispensation and administration of justice, where judicial officers, including judges, conveniently find the resources backing by the law to act on a case where the state has issue with a citizen, but drag their feet and can't find the necessary aspects needed to expedite a case where a citizen wants recourse against the state or one of the state actors. When you do that, also help us map the way forward with regard to what can be rectified in as far as the Constitution is concerned.
Okay, thank you, Chris. I think with the judiciary, our biggest challenge is that we haven't been able to achieve independence as is perceived within the law. Much as our laws provide for distinction between the arms of government, judiciary is under extreme pressure and also under extreme coercion. In many ways, I'll give a quick example from when there was the imminent sale of the Chibuli Mosque, and indeed it was a due lawful process. And shortly before that, we see a letter from the president saying if the law can't provide solutions, apply common sense. Now, much as he may have been well-intentioned, the ill motive about his letter is that it waters down judicial independence. Where a letter is being issued, and as my colleagues here have been saying, where there's an element of coercion or direction, it waters down the role of the courts. Now, if we must even move forward, we must begin to appreciate that the judiciary needs to be independent. The beauty is the laws have enabled us to arrive at that point there. But we are still struggling with the appointment of judicial officers by the president. The other day, a judge who was acting as a judge suddenly was not confirmed. We don't know where she has gone, or what her fate is really. But you can't hold the entire institution at ransom that way. If you expect that we are going to develop our framework and our laws and our country's future, we need to be able to entrench these actors within our systems to be able to do what they must do without any fear of coercion or any kind of duress of any kind. So if we're even to go forward, and as we keep on even demanding for this at the courts of law, everybody must speak up. The courts must be able to take a stance against what the law requires. You find that during the recent protests, they were charging the protesters with the common nuisance. Now that is wrong, because they are seeking to exercise a right under the law to protest peacefully. Now if you find that to be a nuisance really, the courts should be the first point of defense for the public seeking to enjoy their rights under the Constitution. Some of these charges need to be dismissed on the onset because they're a fundamental violation of our constitutional framework and what we expect of our country. Now, if we are to even redeem the situation, good men must begin to speak up. We have struggled because of indifference, we have struggled because of the silence of the good men. The good men must call out the wrongs. The good men must do their duty without fear of repression or without fear of intimidation. They must speak up, and the time is now. We cannot defer or hope for tomorrow to be better without us speaking up today. Okay.
Sarah Virete, there are people or elements within the political landscape who believe that Uganda's dilemmas right now, especially with regard to constitutionalism, are down to one man, President Yoweri Kaguta Museveni. And maybe if he's out of the picture in terms of holding the position of president or even chairman of the governing national resistance movement, the country has an opportunity to rectify what is apparently wrong. Is that correct to think that way? Do you see a Uganda that President Museveni is no longer a leader, and then we effectively begin a process of rectifying what many believe are his wrongs?
Well, the success of any leader is determined by the way he organizes, he or she organizes their succession. Until President Museveni organizes orderly succession, he will not join that history of a successful leader. He came on the promise to power on the promise of a fundamental change, not a mere change of guards. But as time has evolved, you know, his leadership looks more of a mere change of guards than the fundamental change that he promised to deliver. So how would Uganda look like if he was not on the scene? The president enjoys too much power in the 1995 Constitution with about 46 articles that give him power. He literally appoints everybody in the service of, you know, in the institutions of the country. He determines matters of life and death. We still have a death penalty in our constitution, and he's the only person to sign whether you should be hanged or not. He is entrenched in the economy, including bringing his own elements like Pineti and others to access taxpayers' money to do their business. He is in charge of taxpayers' money, but also we've spent 3 years without a Bank of Uganda governor, meaning that he is not only the substantial Minister of Finance, he's now the acting governor, Bank of Uganda, because he has failed to appoint one. That's too much power exercised by one person in perpetuity. That's why term limits were important. To say that the Constitution, because we have an imperial presidency, too much power, and the framers of the Constitution had thought that this power was needed to make sure that the president is accountable to the people and the buck stops with him. But they were also mindful that you cannot exercise all this overwhelming power in perpetuity as one individual. And that's where we lost track completely as a country. So if President Museveni today left the scene, you would have a conversation. We will have too much work to do to rebuild the country, rebuild the institutions of governance, rebuild the citizenry, especially those that pay homage to the president because he brought peace. When you go to the grassroots and they say, yes, the man has done this, but he brought us peace. So we need to deal with those conversations. He brought peace, but we need stability and prosperity for the future of this country. We will have to deal with the state capture that is prevailing. If you look at the ingredients of the Gupta brothers case in South Africa on state capture, all the elements in that case prevail in this country, and even at much grave levels as compared to what the Gupta brothers were doing. So for Ugandans, the transition will be too much work for us, but it will be the necessary work to rebuild this country. Okay,
Honorable Shamim Malende, final word.
Well, Uganda needs a government that is willing to work for its people. For us at NUP, we say a leader is a servant of the people. And we believe that when General Museveni is out of power, one of the most important things will be to rebuild, like Honorable Sarah Birete has clearly indicated. But the most important thing, we are looking at the laws. For example, starting with the Constitution itself, the way it has been tampered with, we feel that we should have that conversation to look at that Constitution and maybe put it back or insert in the necessary provisions and remove what is not necessary. We may also need to look at the laws comprehensively and see where we are supposed to revise and where accordingly we are supposed to live as...
I'm afraid, ladies and gentlemen, this conversation is going to have to be let go. What I know is that we shall have an opportunity in the days to come to amplify it further, but also trigger other conversations with regard to constitutional reform and setting a new path and trajectory for the country. That's it for this edition of Morning at NTV. I'm Chris Higenyi. On behalf of the team behind the scenes, many thanks. I'll be seeing you tomorrow. Have yourselves a lovely day.